And now, live in studio, cutting through your typical media nonsense and offering you a rational and unbiased perspective on current events and life in Tampa Bay. He's a successful entrepreneur, published author, top listing agent, a real estate and finance expert that goes to bat for you every day as a consumer advocate. Your host and the consumer quarterback, Brandon Rhymes.
Hello and welcome in. This is not Brandon Rhymes, your consumer quarterback. Today is James DeGerome, your backup quarterback. Brandon is out today, and we've got the Consumer Quarterback Show all queued up for you. We've got a great show planned for you today. Joining me today is attorney Joe Pippen. Now, you folks out there probably know Joe from his successful radio show. He's been on the air in Tampa Bay for quite a while. But you may not understand estate planning, and certainly I'm one who did not. I understood last night when I was trying to research a little bit for this show that I'm not really prepared as I need to be. So if you're out there listening and you haven't thought about estate planning or wills or probate, there's a lot of terminology that I'm not even familiar with. This might be the show for you because I think Joe can really provide some insight and help you understand what it is that you need to know and how valuable this stuff is. So welcome in, Joe.
Well, thank you very much. It's great to be here.
Tell me a little bit about, before we even start on the technical stuff, you got the radio chops. I'm jealous. Tell me about your radio background.
Well, I've hosted Ask an Attorney all about Florida law now for 34 years.
Wow.
In fact, this month, the Tampa Bay Magazine did a full-page profile article on the longest-running show in Florida, actually. And I've been teased about that, maybe the only body that's been on radio longer than you is the Grand Ole Opry show. But I enjoy doing it. What I did one day is I was used to write articles for the local papers that, they get thrown on your yard once a week. So I had a whole bunch of articles written, and I turned that into a little book.
Okay.
And then one day I took a little stack of books to the local radio station, and I said, if you ever need a guest, I'd be glad to come on and answer legal questions. And I got invited right away to be a guest on a show. And then the manager of the station was there that day, and he said, I did the same thing with an attorney up in Illinois, and it was a really successful show. How would you like to have your own show?
That fast.
And they gave me a 3-hour show. I didn't have to pay for it.
Wow.
They gave me a 3-hour show, and that kind of started my radio career. And that was in 1984.
How about that? So I imagine just like today, folks start lining up on the phone because this is an area that they just don't have access to knowledge that they can trust. I mean, it seems like They're all interested in finding out.
Yeah, everybody wants free information, too. So if you got a professional in there, whether it's a doctor or an attorney or some professional that's giving away free advice, basically, I do a 52-minute straight shot, no commercials.
Wow.
There are no commercials, and I don't really advertise. I'll give out my phone number once in a while on the poster sheet that I gave you to look at earlier. Mm-hmm. I offer to give that away. So we get a bunch of requests every week for that. But that's the closest I come to an advertisement.
And without that, they're lined up half hour before the show starts.
Yeah. Well, unlike you had to prepare a little bit last night, I go into my show totally unprepared because I don't know what I'm going to be asked.
How about that?
So the phones start ringing, and I have a host of characters. Some of them, most of the show questions are educational. There are some very entertaining questions.
I bet.
Once in a while, like a couple of weeks ago, I had a question about a man who wanted to know if he could shoot an alligator that was on his property.
No.
And it got to be funny after a while because I said, no, you have to be permitted. You can't just kill alligators. Sure. They're a protected animal. And he says, what if I tied a chicken to my leg and went over to the lake and then started going backwards and he came out of the lake charging me? I said, we're going to try to use a stand your ground defense on an alligator now when you entice them to come after you. So just a bunch of funny questions. I had a question one time, a lady wanted to know if she could probate her own will. Of course, you have to die first, so she wasn't going to be able to do that. And after about the third attempt of explaining that to her, I think she might have understood.
And that's the idea. Folks out there think you understand what a will. You think you understand what a will is. That's just scratching the surface with the legal documentation that you really need.
Absolutely, and everybody needs at least a will. So I would ask you if you had a will, but I don't want to embarrass you here.
Yeah, please don't.
A lot of people don't. Probably the highest there. When I give speaking engagements, which if anyone needs a speaker for a group, I love to do that, and I do several a week. But I asked the audience, I said, okay, what do you think the most popular option in estate planning is? Mm-hmm. And, a lot of people will guess wills, a few people will guess trust. And I said, nope, the most popular option is doing nothing. because that's what most people choose to do or have done. There's nothing yet. You know, they don't like dealing with dying. They don't like dealing with attorneys. I don't understand that one, but they don't like dealing with parting with their assets. So they put it off and put it off and put it off, and sometimes they never get to it. So
I can see how that happens. Tell me, if you're a single person, why the idea that, oh, hey, I'm single, why would I need, I don't have anything, no family to worry about. It's still important.
Well, see, if you don't do a document, guess what? The state does it for you. So the state of Florida has written a will for you if you don't have one. And there's a statutory scheme of how your assets would be distributed. So if you wanted to give to your parents, if you're not married and you don't have children, then it's going to go to your parents. Suppose one of them's in a nursing home. They could lose benefits because you didn't do planning, and now they're stuck with getting assets where they enjoy where they are and they're on Medicaid. Suppose your parents aren't living, so it goes to your siblings. Suppose one of your siblings has an addiction problem. Now they have a pot of money to use on their addiction, and you could have done a much better plan to help them as opposed to hurt them. And sometimes doing nothing really hurts people. I've seen people lose government benefits. I've seen unwise people that don't know how to manage money get money and they waste it very quickly. Addictions, money's used improperly for addictions when it could have been used for rehab and help as opposed to just giving them a pot of money.
Right.
So a lot of bad things happen when you don't do nothing. And plus it goes through probate, it's costly, and it takes a long time.
So if you're out there and you think, well, I don't have anyone to take care, I'm not worried about it so much, it's something you need to plan. There's no way around it. Yeah, Joe's just telling you about what you must have. There's a lot of things that you should have that aren't even in the critical factor that would make your life a lot easier for those around you if in the event of some unfortunate circumstances. Yeah,
there are a bunch of things in estate planning that would be very helpful. One's a durable power of attorney. Now, what is a power of attorney? You would give someone a power that you trust to do things for you. In fact, if it's a very broad power of attorney, they could do anything you could do. So suppose you have a stroke or a car accident, or you become disabled somehow and you're not able to function 100%. Let's say you can only function 30% for some reason.
Okay.
Well, someone now has the power, because you gave it to them, the power to act on your behalf. And sometimes if you're down to 10 or 20%, you might have to be declared incompetent through a court, which is expensive, time-consuming, and you lose all of your rights, and basically everything you could do has been taken away from you. If you have someone that has a power of attorney, you can avoid being declared incompetent. You can avoid the court, and you've given someone the power to act on your behalf to do anything you could do to avoid all that.
And that's a relationship you had time to develop before the incident occurred, so it's someone that knows how you think or had thought at the time.
Well, it could be a parent or a sibling, actually.
So
in fact, most of the time it is.
Yeah, that makes sense.
And also a healthcare surrogate. So you give someone the power to make healthcare decisions for you. And if you can't make them yourself, guess what? You're going to be declared incompetent. If you sign a document, a fairly simple document, 3 or 4 page document, for example, that gives someone the power to make the healthcare decisions for you, then you've avoided a guardianship proceeding again, because now you have someone that can act in your behalf, look out for your best interest, and someone that you chose.
So these are all things out there that I'm sure I was woefully unaware of. You may be as well. You want to reach out to Joe Pippen and find out where you stand and what you can do to improve your situation, because you don't want to get caught unaware and put yourself and your family in a bind.
Right. Now, if you do nothing, like the will, the will the state makes for you goes through probate. Probate is a very costly process that you can avoid. Normal probate fee is 3 to 6%. It takes 6 months to a year or longer. It's a public record that you went through probate that other people can look at. In fact, people find houses from the probate court that, somebody died. Let's see if they had a house. Let's see if they own a house. Let's see if the estate wants to sell the house. I get postcards and letters every week from people who want the listing on houses on people that they know that I started the probate estate.
Because you're the first one to have that knowledge.
Yeah, well, it's a public record. And they know who the attorney was. And they see who the personal representative is, but they know the attorney's probably the one that's calling the shots and making decisions. So they bombard the attorneys with, let me list this house. Let me help you sell this house. Wow. We'll buy the house from you without with having it listed. We buy houses, and if they're in a search for houses that need to be fixed up, they probably go on the public records and see the value of the house, and maybe they drive down the community and take a look, and they have their little niche of the type of house they're looking for, so they target the attorney basically to come up with the information.
You mentioned a window of some 3 to 6 months in the probate process.
Well, probate takes 6 months to a year, actually.
What goes on during that time period?
Okay, so why it takes so long? When you start a probate, you have to advertise and you have to advertise in a newspaper saying that you're now open up an estate, and creditors have 60 days to file a claim on the estate. So you have to advertise to the world now, so-and-so is deceased, we've filed his will, we've opened up a probate proceeding, and creditors have a time period to file claims against the estate.
I see.
They also, you have to be bonded, so it's expensive. You have to be bonded, you have to pay to advertise in the paper, you have to make yourself open to any claims from creditors, you have to pay known creditors. So 6 months is about the fastest this whole thing could work, but most of the time it takes a little bit longer than that. So we say 6 months to a year.
Understood. Now, that's just part of the process. What are some of the challenges during that process that you have to defend yourself of?
Well, you have to receive, when somebody files a claim on the estate, you have to decide whether it's a valid claim or whether you have to challenge it.
I see.
Once you get started on the proceeding, so if a person had 4 children and they omitted 1 and left to 3, there's a time period now where the will can be challenged.
I see.
The most common challenge to wills are basically undue influence or incompetence. And believe it or not, undue influence is the most popular claim.
Wow.
So that works. Here's how that works. So this happens, or they attempt to do it probably every week in my office. So one of the children now has become a caregiver for the parent. Maybe they might have quit their job, moved from up north to take care of mom or dad at home. So they give up a lot. They come in and take care of parent. They bring parent to my office. And parent wants to change their will. Instead of 3 equal shares, it's everything to 1 or 50, 25, 25 now. But the person that brought them is going to be benefited from the change.
I see.
So now all the other ones have to do is to contest the will, and they're going to allege undue influence. So they're going to get the one who got favored, the one who brought the parent to the office. They're going to ask 50 questions to make them look bad.
Right.
Did you bring them to the office? Were you in the office? Did you talk about this? Did you... they ask them 50 questions to make them look bad, basically, and they usually win in those arguments because they brought them to the office.
So as you can see, folks, we're going to a little more on from Joe when we come back from the break. But as you can see, there's so many details and things you need to understand. This process can be a little bit complicated, and there's factors out there that are attempting to make it more so. To muddy the water. So you need an ally, someone, a trusted advisor. Don't forget Joe Pippen. He's a partner on the show here. Come back and let's find out what the best way to handle this situation would be. ConsumerQB.com.
Hey, this is Jarek Robbins. You are listening to the Consumer Quarterback Show with Brandon Rhymes. Please do what it takes to learn all that you have to live the life you want to live it fully, and find a way to give it by paying it forward to others.
Get in touch with Brandon online at ConsumerQB.com.
Hey, Brandon.
This is the Cannabis Podcast, powered by TrueLeaf on Radio Influence. It's an inside look and the scientific facts in and around the world of medical cannabis. Now, here is your host, Ian Beckles.
He's a successful entrepreneur, published author, top listing agent, a real estate and finance expert that goes to bat for you every day as a consumer advocate. Your host and the consumer quarterback, Brandon Rhymes. You're listening to The Consumer Quarterback, Brandon Rhymes, online at consumerqb.com. Brandon is Tampa Bay's #1 consumer advocate for real estate and financial advice. Call Brandon today at 813-670-7372.
Welcome back. You're listening to the Consumer Quarterback Show with Brandon Rhymes. My name is James DeGerome. I'm sitting in for Brandon today. Joining me today on the show, attorney Joe Pippen, providing quite a bit of knowledge for me about estate planning and all the things that you need to know about wills and probate and that kind of thing. We were just discussing the probate process. I didn't understand really how it worked, and Joe was explaining what it is and what it's about. Let's talk about trusts, Joe.
Okay.
What is a trust?
Well, I call a trust a fancy will.
Okay.
In fact, if you came to my office and you asked me that you wanted a will or told me you wanted a will, I would automatically give you a choice between a will or a trust. But the information that I would need from you is the same for each document.
Okay.
So basically what a trust is, a fancy will, they call it a living trust because you create it while you're living. Mm-hmm. And when you die, the trust is still living. So the assets are not in a deceased person's name upon your death. So the assets in a deceased person's name have to go through probate. Because, if you have a bank account and now you're deceased, well, the bank account is in the name of the deceased, and no one has the legal authority to deal with that asset except going through probate.
Some arbitrator has to make a decision.
Well, no, you need to be appointed. The court needs to give the personal representative nominated in the will the power to deal with that account.
Gotcha.
And only a bank, I like to give this example. So father leaves son everything in a will. He nominates the son as a personal representative and says, I'll leave 100% of all of my real and personal property to my son.
Right.
So father dies. Son walks into the bank with the will, shows the bank the will. Hey, this is my dad's will. He died. Here's his death certificate. Look at this will. It leaves everything to me. Points me the personal representative. He pulls out his ID and says, give me the money.
Right.
You think the bank's going to give him the money?
He can't, because you just said it has to go probate now because he died.
Yeah, so the bank's going to say, well, hey, I don't know if that's the last will. What you need is a letter signed by a judge. It's called a letter of administration. You bring one of those in, and I'll give you the money.
Gotcha.
But if you don't go, you have to go through probate to get that. So when you have a living trust, you create a living trust, and along the way, father would have changed his account name from father to father trustee, date of the trust. So now son walks into the bank with the trust. She said, my dad had a living trust. He brought that in, and he changed his bank. The bank changed his bank accounts to father trustee, date of the trust. Here's his death certificate. I'm the successor trustee.
Right.
Here's my ID. Now give me the money. Well, guess what? They give him the money because it was planned that way.
It makes a lot of sense that the trust makes it seems to be the smarter way to go about it, or the least contested way to go about it.
Oh yeah, it's easy, no probate, quick and easy, no long delay, no 6 months to a year. It can be a lot of times it can be done in a month or so. Sometimes I've done them where people have closed everything in a couple of weeks. It can be very quick. It's not a public record. You didn't have to be bonded, and so forth. And you know what? A lot of listeners out there your age have minor children. Mm-hmm. Well, guess what? You can't leave money directly to a minor child. So what happens then? You forced a probate and a guardianship. So a guardian now has to be appointed the money for the minor. So when you have a trust, you say, I give equally to my 3 children. If one of them is a minor, then the money's held inside that trust until they turn to whatever age you want. So 21, 25. I had a client this morning that did a third of the estate at 25, a half of the remaining balance at 30, and then the remainder at 35. So they did a 10-year stretch. The child was 14. Well, who knows how 14 is going to turn out? Who knows if they're going to have addictions? Who knows who their friends are going to be? Who knows if they can be easily influenced? You don't know. So you do a little stretch at the start.
Makes
and
sense.
then if the child develops nicely, he's got a PhD by the time he's 22 and very financially astute, in control of their life, making good decisions, well, hey, you could give it to them outright if you wanted to. So a trust also, if you have, like we talked about earlier, an addiction family member. Mm-hmm. If you give them their 1/3 outright, guess what? You've just enabled the addiction.
Right.
So what you do is you give them a monthly amount of money, and then you have it subject to random and mandatory testing. And if the addiction pops up, then you suspend the distribution, but the money can be used for medical and rehab.
Makes sense.
So suppose you have a spendthrift. You just stretch out the money. You don't give it to them all at once. You don't allow them to spend it all at once. Suppose you have a child on government benefits. You give them a lump sum of money, guess what? They lose their benefits. So you can have their share, their 1/3 share, go into what's called a supplemental needs trust. So the trustee now of this supplemental needs trust can dole out the money for the extra and supplemental needs to this child. It doesn't disrupt his government benefits.
And at such time as he becomes 18 or whatever, then you can structure that, I suppose.
Well, no, you don't give them money that would disrupt their government benefits. I have a good example is I have a special needs brother since birth. Okay. He's severely handicapped. He's now in a state-run facility in Gainesville. It's a wonderful place, 200 or 300 acres. They have cottages of 12 residents with around-the-clock care. Now, my dad had my brother on private pay for a long time. My dad was the president of an insurance company. He sought out the best care he could get for my brother. But now, when he retired and everything, things worked out to where he's on Medicaid.
Sure.
Now, if my father and I did my parents are both 94 and living and doing well, wow. But I did their estate plan. If I had done that plan to where 50% of their estate went to me and 50% went to my brother, he would have immediately lost all of his government benefits. He would have not been able to stay in the place he's been at for 20 years now, probably. He would have had to go on private pay. All of the money that would have gone to him would have, with the type of care he needs, would have been exhausted very, very quickly. And he would not have been able to return back to where he is now because they're not accepting new patients or clients. So a tremendous mistake would have been made for any parent who would have left money outright like that.
All with the best intention.
Yeah. So the trusts come in handy because you can dole out money for extra and supplemental needs. You can not enable addictions. You can help someone who would spend it and waste it unwisely very quickly by giving them a monthly allowance. Estate planning, you can do great things with estate planning, and if you don't do estate planning, or you sometimes have unwise distributions, you can do great harm.
Yeah, it sounds like even with the best intentions, you can still make mistakes because they're kids. You love them. Of course, you want them to have your assets. You don't think of the consequences.
Absolutely. Now, some of our listeners have pets.
Sure.
So, do you think about your pet doing your estate plan?
I mean, I can see how that would work.
Now, I have clients that have 20 horses.
Yeah.
They want instructions about how money is going to be used for horses. They might have several dogs or cats. They want them properly cared for. Sometimes they're their children. They don't have children.
Right.
Their pets are their children. So there's a lot of special things you can do for pets in your estate plan that you don't normally think about either.
So if you're out there listening and you're thinking, boy, I didn't consider all this, you're not alone. Attorney Joe Pippen has a radio show every weekend, has people calling in for advice all day long because this is an area where people just don't have the knowledge. We're going to come back after the break and talk to Joe about all the different things he does. But before that, trust versus will and the cost of probate, some of the things we did here. When you're asking parents to think ahead or to structure over 10 years, you mentioned one or even more, longer than that, how is the amortization of the money or is the money held with some interest gaining during that time? Or?
Oh, yeah, the trustee that is chosen by the parent can choose where to hold the money. So if they want to have it in a brokerage account,
right,
or a bank account, it can be.
So those are all factors you consider. Where is the money going to be held at such time as they receive the funds? How are they going to be received? There's a lot of details in the paperwork that has to be worked out.
Yeah, the trustee has total control of how to invest the money. Okay. So usually the best thing is to get a good financial advisor, because the trustee is not going to have the financial wisdom about the market necessarily or what types of financial products to do. So the attorney can help with that, the financial advisor can help with that, but it's totally up to the trustee.
Makes perfect sense that you need a team of folks out there or someone with the knowledge to help you get through this kind of thing. And it's difficult to think about, your death and your family surviving, but it's something you better do. And we're going to come back and talk to Joe more about the documents you need to have and be prepared for what might come. This is the Consumer Quarterback Show with Brandon Rhymes, consumerqb.com.
Hey, I'm Ken Shamrock, and you're here with Consumer Quarterback Show. And I say, Brandon Rhymes, Knock out your competition.
To get in touch with Brandon, call 813-670-7372. Online at consumerqb.com.
This is the Cannabis Podcast, powered by Trulieve on Radio Influence. It's an inside look and the scientific facts in and around the world of medical cannabis. Now, here is your host, Ian Beckles.
He's a successful entrepreneur, published author, top listing agent, a real estate and finance expert that goes to bat for you every day as a consumer advocate. Your host and the consumer quarterback, Brandon Rhymes. You're listening to the consumer quarterback, Brandon Rhymes, cutting through your typical media nonsense and offering you a rational and unbiased perspective on current events and life in Tampa Bay. Online at consumerqb.com.
Welcome back. You're listening to the Consumer Quarterback Show with Brandon Rhymes. I'm your backup quarterback, James DeGerome, sitting in the chair today. I've got attorney Joe Pippen joining me on the program. We've been discussing wills and living trusts and all the kind of documentation you require if you're going to face the idea of passing your assets on to somebody else. We had talked a lot about how families have to deal with this, and it's tough to talk about some of this stuff. You've seen some personal issues, I'm sure, where the siblings are engaged in a fight over a particular asset, or they want to change the way the wills or trust is laid out. It can get difficult to mediate those kind of things, I'm sure.
Oh, sure, and I can't represent all the beneficiaries, so usually I can only represent the trustee or the personal representative of the estate. But you know what they fight about most are some of the personal things, like who gets mom's wedding band or wedding ring, and who gets dad's military pistol, and who gets the grand piano, and who gets this painting and this family Bible that's been signed by somebody. And they fight over little small personal things, sometimes a lot more than money. So the way to deal for a parent, let's say, that's doing estate planning to deal with that is the wills that I do, for example, authorize a separate writing. A separate writing is where you can take those special non-titled personal effects, jewelry, furniture, historical family items. You can itemize those and list those and sign it and attach that to the will, and that would properly dispose of those items. So there's a way to deal with the things that you've promised a child. You know, sometimes you get arguments, well, you know, dad or mom promised me this.
Yes.
And no one heard that but the person who took it, you know, so you have no way of really proving it. So the way to deal with that is to do a separate writing where you actually itemize the personal things.
So given that this can become quite personal and you're dealing with family relations that go back years and years, you better find someone in terms of your estate planner or someone you're seeking advice from that you have a relationship with. You're gonna have a relationship over time, and you're gonna want to trust this person. When you figure out who to pick for your estate planning attorney or how to select somebody, is there a logical progression or some way to help guide you in terms of how to find the right person?
Well, you can call the local bar association, for example, and they have a list of estate planning attorneys. You could go to your bank, and their trust department has a list of estate planning attorneys. Friends and neighbors who have had good experiences with estate planning attorneys can often give referrals.
I'm sure that's the basis for most people's feeling confident in their attorney selection.
I've done radio for a long time, so people feel like they get to know me somewhat over a period of years, and they develop a trust, or they like me for some reason. I've done numerous radio and television shows over the years. I was nationally syndicated for 2 years with my show in 39 states and 80-some cities,
so lots
with the
of
same
people
type format. But I can only I figured out that was just an ego trip I shouldn't be on, that I can only practice law in Florida, so maybe I should just stick to Florida law, because the laws are different in every state.
Right.
And, you know, my answers had to be too general because I didn't want to make a mistake or give bad advice, so I can really nail an answer, particularly in estate planning, which is my primary focus area.
Do you find variance among states? How much variance have you found?
Well, yeah, some, you know, like they're California, Texas, or they're community property states. They're totally different than the common law states. There are differences. I was doing deeds for a while. I would do a quitclaim deed in another state, and would find out something that was slightly different in that state I should have known. So I figured, and I'm not licensed in those states, so we quit doing out-of-state deeds a long time ago.
Makes sense.
And we just find an attorney that can help our client with an out-of-state deed. For example, if a client has a living trust and they have real estate in multiple states, well, guess what? You got probate in multiple states, because real estate is probated wherever it's situated. I can create one trust, and they can put all of their property in the different states into one trust, but we need to find an attorney in those states just to do those deeds.
So they could avoid probate in each one of those states, but it takes an attorney that's in that state.
One trust, one Florida trust can hold a piece of real estate in all 50 states. Just that I can't do those deeds in other states. So we just help our client, because you know who wants to go through all of those probates?
Right.
In every case, there's going to be an attorney in that state to handle the probate, and the fees are, you know, our minimal fee is like $2,500 for a probate, and that could be a $50,000 estate.
So big chunk.
Yeah. So if it's, you know, it's 3% or $2,500, whichever is the most. So if you want to, and that would be in every state, you have to go through probate.
Right.
And if real estate's worth, you know, a couple hundred, $200,000-$300,000, and you have multiple ones of those in multiple states, you got really huge fees. But one trust can house all of that to avoid probate in all those states.
Absolutely the way to do it. And then you would also kind of rely on your estate planning attorney to have a network of people in those jurisdictions that would be the contact person.
Yeah, a lot of us belong to the National Academy of Elder Law Attorneys. So, I mean, I could find an attorney in that state. There's also a great website that I direct people to once in a while where you can find an attorney in that state.
So it's the knowledge base and the fact that Joe's been in the market for so long that helps him immediately understand your needs. You may not know what you need, as again, just like me, I'm out there, a single guy with no kids, feeling like, why would I need all this stuff? Boy, you better have your ducks in a row, because you'll get caught in a situation where you're just not able to defend yourself.
Yeah, one of the most important decisions people will make when they're doing a will or a trust is, who do you want to choose as the personal representative? And who do you want to be the successor trustee? Who do you want to handle things? Who's the most financially astute? Who's the most who's financially astute that can get along with everyone?
Right.
Who's going to get to it and get it done quickly? Who's not going to put it off and just let it sit there and not do anything for 6 months?
So you better find someone who has the ability to handle everything that's coming at them in terms of your own family You know what
Yeah,
your
well,
family's like.
sometimes all it is to go find an attorney to help you, and sometimes people just table that and don't get to it. It's be aggravating to other family members. So if you go through, and here's the difference between wills and trusts too. If you had a will and died and it has to go through probate, that whole process is going to take 6 months to a year.
Right.
If you choose the capable, get-it-done type of trustee to take over your estate when you die, then I've had many of those come in where the trustee comes in and I can tell them what to do, give them a list of what to do, and they don't come back. I mean, they can get it done themselves without an attorney very quickly and easily.
What would that list entail, Joe?
Well, with a trust, you have to get a tax number. You have to marshal or collect the assets. You have to pay bills. Maybe get the mail diverted to your place that you receive mail. Collect the mail, discover all the assets, probably liquidate most of the assets and turn them to cash. And all of the beneficiaries are entitled to an accounting. So once they all get their accounting, once they accept this is the final accounting, and you calculate out their share, so I always give them a copy of the check and get them to approve and release the trustee, approve the accounting. When you get all of those back, then you release the money.
Well, you can see how there's a lot of I's to dot and T's to cross, so it may take some time if you don't have your documents in order.
Yeah, we don't just release the checks one by one and hoping they're going to sign the papers and send them back.
Right.
And then if one has a dispute and we have to change things, and we have to recalculate things a little bit sometimes. And so if I have, 3 checks out there and the last one comes in and says, well, I don't agree, you didn't do this or you didn't do that. So now you got to recalculate. You just
those
try
funds.
to get those checks back, and sometimes they don't,
I'm sure most people cash those immediately.
Yeah, exactly.
So part of understanding the law and the differences in the laws in different states, because most people have family members spread out across the country in different locations. They have different levels of real estate investment or different investments. It's really quite a bit, it can be daunting to gather all that stuff and get it all put together so that you understand where you are. You need to start the process regardless of your age and regardless of where you are in your health. In your mind, you feel, well, I'm healthy, I'm strong, I wouldn't need to deal with any of this stuff. That's exactly when you need to deal with it, because once something happens, then you're not in a position to handle this.
Yeah, I had a client this morning that what his plan was is he wanted to have paid on death accounts. So you set up a bank account, you set up a brokerage account, and you name a beneficiary on the account.
Okay.
And he wanted to give different amounts of money to a bunch of different people. So I said, well, look, what happens if you have a stroke and your power of attorney goes in to get money to help you? Which one of these accounts is he or she going to choose? And isn't that going to totally disrupt your plan of what you tried to give someone? Because you've got all these different accounts. I said the best way to do this is to have a trust, get all of these accounts into one trust, and then just give these people a percentage of the estate. And that way, if your estate goes up, everybody gets a little more. If it goes down, everybody gets a little bit less, but you've got it nailed down. You're not trying to juggle your accounts all the time to give someone an exact amount of money on a paid on death account where just that account goes to them, and you've got 12 different accounts with different amounts in each account. The problem is if that money has to be used for your care, how is anyone going to know which one of these are more important to you than the other one? So the thing to do is to marshal everything into one bucket, one trust, and have the trustee pay your bills and distribute the percentage that you want to give this person. And that would be so much better and much more organized, and probably should give you much more peace of mind than what you have now.
And that would be based on the priorities you've established with them prior.
Right.
So that you'd feel comfortable that they know where I stood on this.
Well, sometimes I have to take the total value of the estate, take the amount of money they wanted to give someone, and convert that back to a percentage of their account today.
Sure.
Now, 5 years from now, it's going to be all different. I mean, the amount's going to be different. But if you do it by percentages, then they would all get an amount close to what you intended them for based on the size of their estate.
Be very hard otherwise to handle that because there'd be so many conflicting information and numbers.
Absolutely.
All right, so as you can see, estate planning, very, very important and something most people don't have a handle on. Attorney Joe Pippen's here with us. He'll be here Saturday on the air as well doing his radio show, which he's done for a long time in the Tampa Bay area. We're going to provide some more information for you in our closing segment here. Stay with us. Attorney Joe Pippen on the Consumer Quarterback Show, consumerqb.com.
This is Ward Dunn, and you're listening to the Real Estate Quarterback Show hosted by my man, Brandon Rhymes.
To get in touch with Brandon, call 813-670-7372. Online at consumerqb.com.
This is the Cannabis Podcast, powered by True Leaf on Radio Influence. It's an inside look and the scientific facts in and around the world of medical cannabis. Now, here is your host, Ian Beckles.
He's a successful entrepreneur, published author, top listing agent, a real estate and finance expert that goes to bat for you every day as a consumer advocate. Your host and the consumer quarterback, Brandon Rhymes. You're listening to the consumer quarterback, Brandon Rhymes, online at consumerqb.com. Brandon is Tampa Bay's #1 consumer advocate for real estate and financial advice. Call Brandon today at 813-670-7372.
Welcome back. You're listening to the Consumer Quarterback Show with Brandon Rhymes. My name is James DeGerome. I'm sitting in for Brandon today. I've got attorney Joe Pippen here on the show. We've been learning a lot about estate planning, wills, trusts, and I realized, I didn't have my documents are not in order, and I'm sure a lot of folks listening out there are in the same position I'm in. And when I look at, I did, as I said, I had to do a little research because I did not even have the foggiest idea what all the levels of estate planning are. But I came across a lot of celebrities and famous folks that were in the same position I'm in that did not have any documents in order, didn't have anything in place at the time of their death, and consequently their estate was handled very oddly and with a lot of contested litigation that went back and forth and just very messy. You must run into that all the time.
Well, absolutely. People wait and wait and wait, and sometimes they don't get around to it. I had a call one Sunday morning at my home. I don't know how this lady got my phone number at home, but she called me at home and says, I'm in the hospital, listened to your show for a long time. I'm in the hospital. I want to know if you can come over to the hospital and help me do my estate plan. I said, well, yeah, I'll be glad to. She says, oh, good, thank you so much. She says, I'll call you back. I'm not quite sick enough yet, was what she said. And guess what? She died about 2 weeks later, never having called me back.
Gosh.
And then her family came in, and then they told them about how this is going to have to go through probate and everything because Mom died without a will, even though she wanted to do one, and she might have verbally told you what she wanted to do. Verbal doesn't count in estate planning. And now we have to go through a probate proceeding, and then they almost died,
Oh my gosh.
from the costs. But Prince died.
Yeah.
Channel 13 came out to interview me when Prince died for a little segment about people who don't do their estate planning and what happens when you don't. And we went through that in the first segment. But basically, some of these, somebody else famous died, and they had a handicapped sibling who was going to get money. They're going to lose their government benefits.
Right. They weren't aware.
They weren't aware. And, Prince, how could you have the zillions of dollars that he had and not been worried about taxes? Because you can plan for taxes in your estate plan. To avoid taxes, you can create charitable trust or charitable foundations. He could have paid zero tax and money all gone for good purposes.
It's amazing. One of the reasons I think that I'm unprepared is because I think I don't have anything. What do I possibly have that? And I looked down the list of folks who made the same mistake I make, and it's Jimi Hendrix, Howard Hughes, Bob Marley, Kurt Cobain, Tupac, Sonny Bono. These people are wealthy, billionaires. How did they not consider the fact that all that money is just...
They have multiple attorneys doing various things for them, but just not estate planning.
Yeah. Can you imagine how many attorneys tried to carve that thing
here's
up?
a football story. Joe Robbie.
Sure. Previous owner of the Dolphins.
Without estate planning. And his football, they had to sell the football team. His estate had to sell the football team to pay the estate taxes.
And you realize...
Just lack of planning.
Absolutely an asset he wanted to pass on to his family to keep in the family.
But he couldn't because of estate taxes and no planning.
So having wealth and having attorneys, that does not mean that you're in a good position. It means you've got to get your documents in order.
Now, Michael Jackson died and had a trust.
Sure.
Guess what? He didn't put his real estate in the trust. So his California, was it
Neverland?
Whatever it was, he didn't put that in the trust. So he had an unfunded trust as far as his home, which was a very valuable asset.
Oh, my gosh.
And now that, just because he had a trust didn't mean everything avoided probate. You had to be active to put things into the trust.
And, of course, right away, siblings, family member, everyone starts arguing and fighting over it.
Yep.
Man, what a mess.
And, all of his gold records and things that people wanted or family members wanted. And they would be fighting over those probably.
Sure.
So you can do some bad things by not planning at all.
And it's not as if, as I said, if you're not worried about passing your wealth on to the next generation or your kids or whatever, it's a question of being able to control your assets, period. The state's going to come right in and do what they need to do.
Well, the state, what they do is they set up the system that you have to go through, and they by statute, they have a statutory will. So if you didn't want to leave money your parents, you have no spouse, no children, and parents, and you definitely don't want to leave the money equally to your siblings, guess what? By doing nothing, you did. And if one sibling has special needs or something, you really mess up their life, perhaps by giving them money that now they have to super plan not to have money to keep their government benefits.
Because I think in most people's minds, if they were to die without a will or trust in place, in their head, they're thinking there would be equitable distribution to all next of kin. Just cut it up into equal pieces and give everyone. But that's not the way it's going to go.
Well, it's just unfortunate. People, you work your whole lifetime to accumulate your assets, and you can't spend an hour to get your estate planning done.
Yeah.
And by doing that, you've just allowed now the state to take over, basically, and you have to follow their statutory scheme of things, follow all of their rules, and distribute the money according to what the state statute says.
And, that scenario, I'm sure, plays out a lot, and it's not great. But think about not dying, but becoming incapacitated, and you have not made these decisions.
Well, that's worse, because guardianship is ongoing and very expensive.
Yeah, that would be the absolute worst situation I could imagine.
And speaking at seminars, which, again, if you'd like to have me come to speak to your group, usually just turn it into an Ask an Attorney show, speak a little bit and answer questions from the audience. I would love to do that. My toll-free office number for either appointments or speaking engagements is 1-800-226-3529. One of the things I get from the audience once in a while, the husband will raise his hand and say, well, my wife and I own everything jointly. Doesn't it just automatically go to my spouse if I die first?
Right. That's an assumption I would make.
That's true. So I said, well, look, yes, it would avoid probate, but, most times I get that question from the husband who thinks he's going to die first, so he never has to worry about it. Right. And then you leave the burden on your spouse, who's going to be distraught and depressed for a couple of years, not wanting to really get to it herself. And it'd be so much better if husband and wife would do this together.
Sure.
So it's all done when the first one dies.
It makes a lot of sense. You don't want to have to do these things at that time of duress, when you're under duress like that.
Yeah, and it's just because you're going to die first, don't leave the burden on your spouse.
Right.
Either way. Because guess what? The one who dies first is the one who writes the checks, makes the investment, makes most of the decisions. And now the one left behind is stuck with a new job, something they've never done, probably don't want to do, but now they're stuck with it. And plus they have to deal with having just lost their spouse as well. And
perhaps the anxiety of dealing with other creditors or people coming after some of the assets.
Exactly. And, then they're just going to go downhill even faster.
So you've been in a position where you've luckily seen a client defend themselves by having their documentation correct and have being able to survive an attack from another litigant trying to make a claim on that estate.
Oh yeah, if you do your estate planning properly, then you've set yourself up to do the very best you can and the best for your family, and to deal with issues like that. And part of what we do, as well as estate planning, is asset protection planning. So there are a list of assets in Florida that are exempt from creditors. Like your homestead's exempt from creditor. Nobody can sue or take your home. And even if you go in a nursing home, that's a non-countable asset that doesn't count against you for qualifying for Medicaid.
I'm not sure I understand that, Joe. Explain that one time.
All right. So to qualify for Medicaid, you basically have to be poor.
Okay.
So the house in Florida, your homestead, is free from the claims of creditors. So basically, for Medicaid planning, it's a non-countable asset. So the value of the house does not disqualify you for Medicaid.
Okay.
And then when you die, the homestead can descend to your children, free from the claims of any creditor. So if you built up this huge nursing home bill over the many years you stayed there, they can't come take your home. For lawsuits, insurance products, annuity products, and retirement accounts are exempt from creditors.
Okay.
So you have a big car accident on the way home today, they can't take your homestead, they can't take your insurance, they can't take your annuity, they can't take your retirement plan. Those are exempt assets from a lawsuit. So most of the times on asset protection, we strongly advise a person to have an umbrella policy. So they're going to have an insurance policy over top of their regular car and home insurance. So if you have $1 million umbrella policy, which might cost $600 or $700, and you're involved in a lawsuit, most likely that would be enough to settle the lawsuit without the insurance company popping out their $100,000 and saying, well, the rest is on you. Then you have $1 million worth of extra coverage for just a little bit of money. It's called an umbrella policy.
Now, you determine at what time that makes sense based on the value of the assets that you have?
Yes, and the liability, well, you don't want to lose your house, you don't want to lose your car and your bank accounts and everything if you can help it. So for a little bit of money, you can get a policy to cover you cause a 30-car crash on I-4.
Right.
I mean, you're going to have some big liability there, and if you were at fault, you can at least have enough. You might not have enough coverage of $1 million for that many accidents that you caused, but that's what most people do to protect themselves.
Listeners of the Consumer Quarterback Show know that we take great pride here on the show of providing information and knowledge to you. And certainly today, Attorney Joe Pippen did just that. I was completely uneducated in the world of estate planning and wills and trusts and what they are. And I hope most of you out there are not as uneducated as I am about this, because it sounds like it's very important and it's something that you need to take care of. Joe's got the show Saturday. What's the best way to get in touch with you, Joe? I'm sure people want to talk to you.
Yeah, if you would like my free estate planning poster sheet, which covers a lot of the things that we talked about today, you get it one of three ways, and you can use this also to contact us for appointments. You can call the 1-800 number, just 1-800-226-3529. That's 1-800-226-3529. You can email me, Joe, J-O-E. I need your name and address if you want the poster sheet, J-O-E at ATTYPIP.com. You can text me at 727-667-3967.
That's Attorney Joe Pippen here on the Consumer Quarterback Show. Great show today. We're so happy to provide that information to you. We want you to consider committing a random act of kindness. Just like Brandon says, go out there and be nice to each other. Let's not be divisive. Let's be together. Let's unify each other, huh? Consumer Quarterback Show, consumerqb.com.
You've been listening to the Consumer Quarterback, Brandon Rhymes. Whether it's real estate, consumer, or financial advice, let Brandon call your next play. Contact Brandon Rhymes at 813-670-7372. That's 813-670-7372. Online at consumerqb.com. And join us next time for the Consumer Quarterback Show, weekday afternoons at 5 on AM 1380. The Biz.
Are you a real estate agent looking to take your business to the next level and supercharge your marketing? Hi, I'm Brandon Rhymes, owner of Platinum MVP Realty and host of the Real Estate Quarterback Show, syndicated radio and TV show talk program on iHeartRadio, 1025 The Bone, daily 5 o'clock drive time on 1380 The Biz, and our TV show is on WeBeam TV. We're looking for real estate agents that want to join our team and supercharge their marketing utilizing some of our innovative strategies. We utilize the Real Geeks platform, Facebook marketing, internet marketing, and a lot of the traditional methods as well. Postcard mailers mailed for you, postage, signage, business cards, all paid for by the company. Aggressive real estate splits and ways to help you win in any marketplace. We need you to go out, take applications, and work our plethora of leads that we're generating on a daily basis. Reach out by clicking the form below, and we'd love to have a confidential interview with you.